Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting very shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the...
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for today's online title, Navigating the Skies, an Overview of Aviation Law in Malaysia. My name is Joyce Wong. I'm an associate with Ma Wen Kuan Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce you the firm and what we do. Ma Wen Kuan Associates is a mid-sized law firm that was founded in 1985. Our able team today comprises of 33 lawyers and a support team of 32. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups are some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcast live. But with the COVID-19 MCO, we have moved online in order to continue our objective of sharing knowledge, raising awareness, and encouraging network for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. The details will be given at the end of this talk. Now, allow me to introduce our speaker, Ms. Cassandra Nicole Tomasios. She was called to the Bar of England and Wales in 2011. She was admitted to the Malaysian Bar itself. She is now a partner in corporate and aviation departments. She holds an LLM Masters in Law in Transnational Law from King's College London. She is also a HRD Corp certified trainer. Her areas of practice includes commercial and corporate matters, M&A transactions, aviation law, and corporate regulatory advice. Now I pass the floor to Cassandra.
Hi, everyone. Thanks very much, Joyce, for that. Thank you all so much for taking time off your busy schedules in the afternoon for joining us as well. Just a reminder, if you have any questions, please feel free to pop it into the Q&A box at the bottom, and I will do my best to answer as many as we can at the end of our session. So without further ado, I'm going to take you, I think most of you can appreciate as well that for aviation law as well, it is a very broad topic. And so with that being said, we aren't able to cover as much as I would like to cover today, but I will try and do my best to answer as much as I can if you have specific questions. The initial start of our talk today will go through a very brief overview of aviation law. Imagine it being an umbrella. So I will give you an umbrella overview of what exactly it entails in terms of legislation, key laws, regulatory bodies, licensing bodies, international treaties, which involves a lot of regulation as well. And then we're going to try and streamline the end of our talk to focus predominantly on airport operators, its operations, which include things like ground handling, safety procedures, and specific agreements that airlines typically use. And as most of we don't have that many airlines in Malaysia, but like Malaysia Airlines, AirAsia, Firefly, and things like that is quite streamlined in terms of the agreements that they use and infrastructure. So we're not going to cover a lot of case law, which involves safety issues and protocols, because that involves, there's so many different areas of aviation law. But if you have any questions or if you have any suggestions at the end as well, please feel free to suggest any specific area of aviation law that you would like us to cover in our next webinar, and I'll be happy to do that. So I won't waste so much of time, and I'm going to go and jump in straight to the next slide, which, like I said, is an umbrella to basically give you an understanding of what aviation law might entail. While there is no one fixed definition of aviation law in general, the gist of it basically governs certain things like air navigation. This includes your aircraft space, your routes that different airlines take, aircraft operations, which include anything to do with the airlines and the aircraft itself. It can be ground handling, it can be safety of operations, it could be leasing, it could be sale and purchase agreements for your aircrafts. As you all know, we have different types of manufacturers in aviation. You've got Boeing, you've got Airbus, and so they all come under the umbrella of aircraft operations. And while it's too wide to cover, I'll do my best to streamline what main pieces of legislation you need to look at in Malaysia if this is the space that you're working in. Most laws and regulations, not only in Malaysia but across the world, are predominantly influenced by international treaties. What this means is it's basically an international treaties, which is a global framework, which covers things regarding safety, security, development in the sphere of international air transport. And these key treaties, which I will take you through as well, sets the fundamental principles for airspace in general. Now, these are operational standards which are standardized across the board. And the reason why it's needed is because imagine if we had different countries all over the world having their own fundamental principles for aviation. That wouldn't be possible because as aviation predominantly covers cross-border transactions. Your agreements are almost always cross-border, save and except unless you use ground handling companies within your country. But it would still be cross-border because you need services every time the aircraft travels from one country to the other. One, you are crossing international airspace. Two, you are using services outside your country. Three, you are liaising with companies, regardless of whether it starts from aircraft operations, airports, infrastructure to ground handling in other jurisdictions. So what this means is that there needs to be a set of fundamental principles which are universal. Now, this is not comprehensive at all, but imagine it being like an umbrella, like I said, where each individual laws in the country, and I'll take you through this as well, is bring more or less on these fundamental principles. And these principles can include things like the Chicago Convention, and they create standardized international system for air travel in general. Now, with that being said, there are two main categories within the aviation legal sphere, which is segregated into public and private. So public aviation law would govern things which requires government regulations, and this could be airspace, safety, these are universal, and these are government regulations. Private aviation law is a little bit more private and commercialized because it includes things like contracts, insurance, liability, and they're very focused specifically on airlines. An extension of airlines now also includes private jets and drones. So these are the two main categories, which we will try not to delve too much into because we're just doing an overview today. But like I said, if you have any questions, please feel free to put it in the chat. As promised, we now move on to key international treaties and bodies, which I'm sure most of you already know. So for those of you who are quite familiar with the aviation space, you would know that key international treaties involve these three main ones, which is the Chicago Convention 1944, the Montreal Convention, and the Tokyo Convention. Now, the Chicago Convention establishes principles for international air navigation, all right? Navigation, which means this includes your international airspace cross-border over countries. Some airlines are not allowed to cover or fly across certain countries. Some airlines are restricted in terms of airspace, and these are the things that need to be governed universally. We then have the International Civil Aviation Organization, also known as ICAO for short, ICAO, and their really cute logo is here on the slide, which you can see. And for those of you who didn't pick up, the ICAO logo is very similar, actually, as you will realize, to the United Nations one. It's embedded within their logo, which you can see. And that's because ICAO is actually a UN agency. They are a United Nations body, which helps several countries, I think 195 or 180 countries, to share the skies with mutual benefit. It is a specialized agency of the UN, and it coordinates principles for international air navigation between countries and their airspace. Planning and development is involved because some certain airspaces are open to some airlines and they expand as we go along over the years. It ensures safe, orderly growth in the international sphere. So that's ICAO. We then have the Montreal Convention, 1999. This generally covers carriers' liability. And by carrier means aircrafts, airlines, it governs liability and passenger rights. Passenger rights in relation to delays, flight issues, unruly passengers, behaviorally wise, if there's any incidents that occur over the skies. This is where the Montreal Convention comes in. Now, the Montreal Convention is 1999, if you see, which is the most recent. And that's because it largely replaces an earlier convention, which is called the Warsaw Convention. Now, that was in 1929. So you can imagine how many years ago that was. We've moved many years on now, and it replaces that because that was a little bit fragmented. So Montreal Convention is a little bit more universal, compact, and it is a consolidation of the Warsaw Convention. And last but not least is the Tokyo Convention, which is quite limited. It's the smallest of the lot. It just sets standards for dealing with offenses that take place on the aircraft in the skies. And the last logo, which you see here, is the International Air Transport Association, IATA for short, which is an international industry trade group. Now, please bear the difference here. A lot of people always tend to confuse this. ICAO is a UN agency, whereas IATA is an international trade group, specifically for the airline and aviation industry. It's headquartered in Canada, and it governs the international air transport, but it's an association. It is not a regulatory body, okay? Malaysia, for those of you who want to know, for international treaties, how it works, in order for you to abide and embed their regulations into your local legislation, you should be a signatory, or as they call it, a party to the international treaties. Malaysia is a party to these three conventions, the Chicago, Montreal, and Tokyo Convention. We move swiftly on now to the most exciting part, which most of you, if you are lawyers or if you are in the legal field, these would be the pieces of legislation you should be picking up and you should be reading and you should familiarize yourself with. It is the Civil Aviation Act, also known as the CAA for short in Malaysia, Civil Aviation Act 1969. Along with that comes the Civil Aviation Regulations 2016. This is the most recent and the latest pieces of regulations in Malaysia. We then have the Malaysian Aviation Commission Act 2015, the Carriage by Air Aviation Offences Act, and the very broad umbrella contract and tort laws. Now, I'll get into a little bit more detail about that on why you see contract and tort here, but I'll take you through each of these step by step one. So the Civil Aviation Act mainly governs flight safety, airspace use, and pilot licensing. As we all know, we can't have anyone simply get onto an aircraft and fly the aircraft. You need to be a licensed pilot. The Civil Aviation Act sets out exactly what is required for a pilot to be licensed and allows CAAM, which is CAM, and I will just quickly go to the next slide, but we'll get here as well. CAAM is the Civil Aviation Authority in Malaysia, which is the main governing body in Malaysia for aviation, all right? They are essentially mandated by the Civil Aviation Act 1969. We then have the Malaysian Aviation Commission, which establishes MAVCOM. But excitingly enough, I will go through in the next slide how MAVCOM is no longer around. It has been, I would say, merged with CAAM, and we will go more into that shortly. Now, Carriage by Air Act, as we previously saw in the international treaties, applies the Montreal Convention into Malaysia. So it governs compensation for baggage loss, flight delays, and issues relating to passenger rights. And that is the carriage by air. Other relevant laws that you have in Malaysia include contract and tort law. Now, most of you might be thinking, why? The reason for this is because airline liabilities go based on contract. When you buy that flight ticket, most airlines have their T&Cs at the end of their flight ticket, or more so, it's also included in their terms and conditions online on their website. So yes, Singapore Airlines, Malaysia Airlines, Etihad, Emirates, all of them having their different airline liabilities, terms and conditions on what to do if your flight is delayed, if your baggage is lost, what can you do to claim if your flight has been rescheduled. These are all elements of contract law because it is offer and acceptance based on you buying your ticket and accepting to that T&Cs, depending on the airline, and which goes back to enforcing contract laws. As many of you will know, and we'll get into a little bit of this trend at the end of the talk today, when we were down with COVID, airspaces were closed. Airlines made major losses. And during COVID-19, a lot of flights were cancelled. And people had bought flight tickets way in advance, 2, 3 years, 5 years in advance, only to realize that they might not be getting on that flight because airspaces are closed. This then brought about a lot of cases in courts, precedents, and arguments for lawyers that had a gala time with it relating to contract and tort law. What can we do in passenger claims? What can we do with airline liabilities? What can we do about our rescheduled flights? And this is when a lot of individuals and people then turned around and to read the fine print, which most of us didn't bother doing back in the day. So these are some of the exciting pieces of work that we have within the umbrella of aviation law. Now, as I was saying, for regulatory bodies in Malaysia, the Civil Aviation Authority in Malaysia, also known as CAM, is the main governing body that oversees technical certification of airports, safety, its navigation, anything and almost everything you name. MAVCOM was the Malaysian Aviation Commission that was officially dissolved and its functions were absorbed into CAM as of the 1st of August 2025. So 1 month ago. This was following the Malaysian Aviation Commission Dissolution Act in 2020 and officially came into force on the 1st of August when MAVCOM was dissolved. And that's the reason why now the Civil Aviation Authority in Malaysia is the sole regulatory body for civil aviation in Malaysia. Previously, MAVCOM used to be the governing body that issues something called an AOL license, which is needed for any commercial airport in Malaysia. So you would see Malaysia airports, for example, KLIA1, KLIA2. In order for you to create, set up, build, develop an airport, you need an AOL license. Because MAVCOM has been dissolved, that function now falls under the Civil Aviation Authority of Malaysia. The Ministry of Transport also plays a role for regulation in Malaysia, but not really in terms of issuing licensing or regulations, but more so they oversee aviation policy. So when it comes to things like pieces of legislation that needs to be implemented in Malaysia or revamped or amended relating to aviation, that's where the MOT comes in, which is the Ministry of Transport. All right, they are in charge of policy formulation as per what it would be expected because they are a government body. And as well, we're going to move on to licensing and regulations. Again, I'm giving you piecemeal information, which is quite brief. Each of these subheadings, we can actually go into rather great detail, of course, but we don't have the time to do that. So I'll take you through each of the licensing and regulations needed in Malaysia, but these are not comprehensive where they include all the requirements in terms of what you exactly need for each license. You can come speak to us if you need any information regarding that in more detail. So regulatory bodies involve licensing and regulations in Malaysia. I'm going to focus because there's too many. We're going to focus not on pilots, not on licensing of pilots, but we're going to focus on airport operators. Now, regulatory authorities involved in Malaysia, it is the Ministry of Transport and CAM, which is the Civil Aviation Authority of Malaysia, relating to what we call an aerodrome or an airport operator license, AOL for short. It is issued under a piece of legislation. It covers several things ranging from passenger rights, baggage handling, ground operations, how your airport should be organized, handled, and regulated. Now, this was previously issued by MAVCOM under Section 35 of the MAVCOM Act 2015, but this has now been absorbed by CAM, where it is still mandatory for any operator opening an airport to have an AOL license, but it's not issued by MAVCOM anymore. It is issued under CAM. And moving on, what we have is safety and security oversight by CAM. Now, they essentially enforce the international treaties and standards under ICAO, which is an organization that issues regulations on an international level. And they review audits for airside operations, emergency preparedness. So most airports you have seen, whether it's Senai in Malaysia or KLIA, or previously we had Subang Sky Park, they would almost always have a mini fire, I wouldn't say a full fire station, but they would almost always have a fire station in the airport on the side with about 2 to 3 fire engines, depending on how large that airport is and whether or not it's a local or international hub. The reason for that is because it is a requirement under international standards and international treaties for us to embed in our local policy, embed in our local laws that we must have emergency preparedness at every and all airports. So part of safety and security oversight by CAM includes that the licensing issued to every airport operator, such as an AOL license, needs to have a requirement that their emergency preparedness is ready. And this is reviewed and audited every year, if not every 2 years, to ensure that the emergency system and emergency preparations for each airport are essentially working in operations up to date and abide by the local and international regulations. Now, this is important for safety and security, and it's part of an international standardized rule and regulation that even if you go to an airport in Malaysia or Indonesia, they would have it because it falls under the ICAO standards. Okay, I've summarized more or less the framework of licensing and regulations in this table that you see on your screen, which involves the various regulatory bodies, of course, with the exception that this is outdated and MAVCOM has been dissolved. And even where you see economic regulation here and safety airside operations, it now falls under CAM. Okay, so moving on to the exciting topic of airport operators, because all of us, I'm pretty sure, knows Malaysia Airports. Some of you refer to them as MAHB for short, Malaysian Airports Holdings, Malaysia Airports Sepang, we've got just Malaysia Airports, Senai Airport as well. Companies such as these are essentially AOL holders, like what I've mentioned earlier. They are licensed and they are given mandate to operate airports across Malaysia. Malaysia Airlines operates, I'm not sure if this figure is up to date, it might not be, 39 airports across Malaysia because we have several states and KLI, in fact, KL has 2, KLI 1 and 2. They hold the airport operator licensing, not from MAVCOM because previously it was MAVCOM. Now it is for any new airports that would like to be established. It would be CAM. This will get a little bit technical. I hope all of you bear with me. It is very comprehensive in terms of the list of agreements and contracts and documents that are involved for aviation. I will not be going into detail for everything, but I will give you a taste of what types of agreements are used for what type of transactions. Several airlines and airport operators around the world may not use the same language, which on the screen now, because they may call it different things in different jurisdictions, but they are essentially the same. Not exactly the same, but more or less the same. So to start off with airlines specifically, and when I refer to airlines, I refer to Emirates, Etihad, Malaysia Airlines, AirAsia. They are airline entities, companies. They have airline agreements which involve SLAs, which is service level agreements, but they also specifically have contracts relating to, one, the use of their airline and the airport. So there are different transactions and relationships here. You have relationships between airlines and airport operators. You have a relationship between airlines and infrastructure staff. So you have ground handling operations, you would have the use of an aero bridge. All of these are third-party operators, which most probably may not necessarily fall under the airport operator itself. So when you go for a flight between here and Singapore, for example, that's too short. Let's say you go for a flight between here and Japan, and you're heading to Tokyo. You most certainly have food on your airline. Now, that food is provided by a third-party operator because it cannot be the same operator that's based in 150 jurisdictions around the world or 150 flight routes, which the airline has. So in each country, what they do, they enter into separate contracts with ground handling staff, food caterers, different third parties for usage of services that the airline needs in that jurisdiction. So that will form different agreements which is actually not here, for airlines. You then have airport use. So in every country, your airlines and your aircraft will land in an airport. Now, in that airport, you would have airport operations infrastructure. This could be that they need to assist in ground handling, cargo service, retail operations, airport uses. Now, airport uses is what I'm focusing on here. The core agreement between an airline and an airport operator is predominantly to set the terms for the runway, because the runway is owned by the airport operator. Ways, parking, which by the way, airlines need to pay for. Airlines need to pay if you spend a certain more time to park your aircraft in their airport. Time is money. And it also involves passenger terminals, lounges, ticketing staff, check-in counters, gate usage. These are things which airlines need. It's mandatory to use at airports. And to govern this, you would almost always have an airport use agreement between the airline and the aircraft. So this is one of the issues that sometimes comes under default because some airlines and airport operators have issues and disputes as per all contracts. This includes duration of the access which they have to the airport, suddenly being denied access to the airport for any reason whatsoever. Charge and fee structures. 1 minute airports have a fixed fee structure, which includes landing fees, parking fees, and they may change over the years. Is there a clause in the agreement to state how many percentage they can increase that by? So these are the things which pop up when drafting, when legal professionals are drafting agreements that you might need to think of. Operational procedures, insurance and liability clauses are some of the examples that we take note of. Then we have things like ground handling services agreement. So this is, I feel, very important because aircrafts cannot operate without ground handling staff. When I refer to ground handling staff, they are usually almost always third-party providers, but some aircraft operators like MAHB, Malaysian Airlines, for example, have their own ground handling staff. It depends which ground handling service provider you are using in a country. It could be Dubai, could be Indonesia, could be Malaysia, but they cover service like baggage handling when your baggage is delayed or one of the staff under this third-party providers have damaged your baggage. Aircraft cleaning, it's not the airport operators that are cleaning your aircraft, it's a third-party service provider. Refueling coordination, refueling and engineering staff also are third parties that are provided by companies in the event anything goes wrong or emergent services is needed in a different jurisdiction. That's ground handling. You then have the sphere of terminal leasing and space rental. So this includes renting terminal space for, let me give you an example. For Malaysian Airlines that have premium lounges, that is not an aircraft lounge, it is an airport lounge. It is owned by Malaysian Airlines and they rent the space within that terminal from the airport operator. These include space rental agreements as well. Utility costs will be something to think about when you're drafting electricity, water, internet. You've got sometimes really fancy premium lounges that essentially take up maintenance obligations, which you have to consider when you're renting space. And some of the airlines obviously are more premium than the other. You've got Etihad and Emirates, which have very premium lounges all over the world, different airports. They would need to rent out space in these airport terminals. Okay? Like I said, I'm not going to go through all of this, only the main ones which we need to take note of. You then have service level agreements. Everyone knows SLAs for short, service level agreements, SLA, predominantly set performance expectations. And these, I would say, are very important, similar like IT software contracts, for the main reason why. When you have airports which run on a very strict time basis because flights have to take off, otherwise they pay extra money on the tarmac for every hour that the flight is delayed. When you have performance expectations from third-party providers, baggage delivery time, turnaround time, sometimes an aircraft may arrive in half an hour, they need to take off again. You sometimes are sitting in the terminal and passengers exiting. 10 minutes later, you see new passengers entering that aircraft. AirAsia is very famous like this. They have a turnaround time, which is very quick, and they reuse the same aircraft to fly different flight sectors. The turnaround time here is key, which is why you need an SLA, service level agreement, to state who is going to be penalized and who is responsible in terms of compliance for any delay that we have. If the aircraft is not cleaned in time, if food is not replenished within that 10-minute or half an hour window, if your cabin crew has not been turned around quick enough in order for the next set of passengers to get onto a plane, Who's responsible for this? Who bears the penalties? Who bears the amount of money that is going to be implemented by the airport? These are things that are usually encompassed in your service level agreements. And it is very common for these SLAs to be reviewed with a very fine tooth comb. So that's a rough overview of some agreements. And then we have the exciting ones, which all lawyers want to do, which is the sale of an actual aircraft. Costs millions of dollars. And you have two types, predominantly, of course, along with others. You have different financing roles involved here, but I won't get into that just yet. The main one is the sale and purchase agreement. It's the same like buying a house. You buy a house, you sign an S&P, you get the keys. For the aircrafts, it's the same, but there's a lot more due diligence required in terms of reviewing the entire aircraft history, which in something called a logbook. This is the main contract when you buy aircrafts, either from airline to airline. Singapore Airlines is selling their airline. Malaysian Airlines wants it. They strip it, they buy it, they do the transaction work. It then gets rebranded under Malaysian Airlines. Sale and purchase agreement, same like houses. It involves a buyer, a seller. It has very specific details for the aircraft, like model, serial number, condition, logbook, flight sectors, number of flights, number of routes, number of passengers carried. Very comprehensive. And then, of course, it has a purchase price. How many millions is this aircraft going to cost the airline? Nowadays, in this day and age, it is also becoming increasingly important to review warranties in an aircraft S&P. The reason why I say this is because over a couple of years and several years, the airworthiness of aircrafts decrease. Maintenance history should be checked, like buying a car. If you were to buy a car, you would almost most of the time take it to a mechanic, especially if it was 10 years old, to see whether everything's in working order. Oil, brakes, things like that. Aircrafts are similar, except there's more detail that is expected, especially for due diligence, because you're carrying thousands of passengers on a daily basis. Similarly, you would expect that most aircraft sales are cross-border. And so what you would need to specifically be wary of is governing laws across jurisdiction and dispute resolution clauses. You might have an entity or an airline in the UK, for example, buying an aircraft from the US. That's quite unlikely. But with that being said, the dispute resolution and the governing law needs to be clear as day, with many of them choosing arbitration in a neutral third-party country like Singapore, the UK, or Hong Kong for that matter, to govern things that specifically are set out in T&Cs where there is a breach. Nowadays, though, however, most airlines do not outright purchase aircraft. They instead lease them. Airlines often lease aircrafts rather than buying them because it provides fleet flexibility. And common lease types would be an operating lease or a finance lease. The difference between the two is that an operating lease is short-term. There's no ownership transfer. It's like renting a property. You're leasing the aircraft over a certain period, over a certain term, and you don't own the aircraft. Finance lease, however, is basically a longer term. It's when you have the option to buy the aircraft after a certain period of years. Something similar to housing where it's rent to buy. And this also includes very comprehensive terms and conditions when it comes to maintenance responsibilities, only because when you don't own something, you have to ensure that you, as the lessor person leasing the aircraft, maintain it to a certain degree and to a certain standard and extent that the owner would like. These are the terms and warranties and indemnifications you have to give, because when you return that piece of commodity, when you return that asset, it needs to be in a condition which is satisfactory to the owner, which is understood. And last but not least, you have aircraft maintenance and support agreements, which are often signed with manufacturers. Manufacturers, maintenance, repair, and overhaul providers typically provide airlines with maintenance and support services. These are typically charged on power by the hour, which means you pay based on actual usage whenever they come in to maintain and support. And it could be service contract as well, where it's a lump sum. We pay you this amount for maintaining and supporting our aircraft. We have this amount of fleet. Typically, you don't find an airline signing a maintenance and support agreement for one aircraft. It would usually be a maintenance and support agreement for a fleet using the same third-party provider. And these includes things like schedule checks, engineers, part replacements, urgent work required if you're a foreign jurisdiction. For example, you've flown a Kuala Lumpur, Dubai sector, and the plane has an emergency, or the plane has issues, or the plane needs to be, a part needs to be replaced in Dubai. that's where your support and maintenance third-party provider comes in. I think I've more or less covered the types of agreements and airline operators that typically sign these type of contracts and agreements. And now we're going to move on to a general overview of what the trends are. This is not universal, this is not international. I'm predominantly taking key trends that we see in Malaysia. One is consumer rights. So we've got flight delays and cancellations in Malaysia for several different airlines. I don't know if most of you don't know, or if most of you do know, over our Merdeka celebrations last weekend, a week before that, our airspace was actually closed from 8 a.m. to 11 a.m. or 12 p.m. or something like that for about 5 days up until Merdeka. And the reason for that was because our government was then doing trainings and rehearsals in anticipation for our Merdeka Day celebrations. This incurred several flight delays because, as you can imagine, many scheduled flights which were due to land or take off between 8 a.m. and 12 p.m. now had to reschedule or cancel their flights. Passengers under international law and local law and regulations would be entitled to compensation. This is when key issues and trends that typically occur within the aviation law, aviation legal space in Malaysia, I would say 60 to 70% of most claims involve consumer rights, passenger rights, and most of the time it's either baggage loss, flight delays, cancellations. So this is the run-of-the-mill issues that occur in Malaysia. You then have now, with the aftermath and during 2 years ago, we had the impact of COVID-19. We had airlines and airports facing tremendous losses and tremendous legal and commercial challenges because, one, they were not making profits, they were not making large sums of money since people were not flying, but then you also had airports that had to maintain their airports in terms of internal maintenance. They still had to pay for that, but there were not many passengers and airports were empty. So you then had issues of flight refunds, airport operators losing millions of dollars, and force majeure clauses suddenly coming into a very dominant trend of key legal issues. And the reason for that is because everyone was relying, am I exempted for paying X, Y, and Z because this is beyond my control? No one expected COVID-19. Everyone was scrambling through airline agreements, like the same agreements, and I'll go back and show you. You would have agreements like airport use. You would have ground handling services. Do I still charge them? Is the third party still going to charge the airline for use when they're not using? Is there a force majeure clause in my agreement to state that if something like a pandemic or an endemic or an earthquake or a volcanic eruption happens, I'm exempted for that payment? Everyone was suddenly scrambling through their aviation contracts and documents linked to their transactions on whether there were force majeure clauses. So this was a key trend and issue which is slowly dying down, but was interesting at that time. Something new and exciting now is a drone regulation. I don't know if many of you have seen drones, but it's becoming increasing use, not only in Malaysia, but across the world. So there are now new safety guidelines and rules issued by the Civil Aviation Authority of Malaysia, which requires people who own or fly drones to have a permit for commercial use. So if you are doing it privately in your backyard, in your garden, there's a certain height limit that you can go up to. But if you are using it for commercial use, for example, there was an event, and I think it was also in conjunction with Merdeka, where an event company required the use of drones to make flowery, very colorful lights in the shape of a wording on top of the Petronas Twin Towers, for example. That now requires a permit to be approved before you can use the drone, okay? And last but not least, a new trend I would say is the liberalization of air routes. More foreign airlines are entering Malaysian market. We didn't have this many airlines coming in, say, 25 years ago. And that creates legal issues around competition, landing rights, from our local national carriers to foreign carriers and airlines as well. So running short of time, I'm not going to go into these case laws, but I'm just going to leave you with this. Things to think about that might spark questions in your head or that might spark answers that you might consider would be common aviation cases and examples. Key legal challenges today include regulatory harmonization. Are we harmonized, standardized, and uniform in our regulatory compliance? And are they up to par with international standards? Post-COVID recovery, a lot of airlines are recovering from that. Drone integration, like I mentioned, this is new. Cybersecurity issues, PDPA, personal data, airlines handling several information, IC numbers, passport numbers as well, and aligning ICAO safety and environmental standards, which everyone is moving to, is our airline carbon dioxide emissions up to environmental standards. 35 years ago, you didn't have carbon emissions. If you notice now on your flight ticket, I'm not sure about all airlines, but I'm pretty sure Etihad and Emirates, and your flight tickets, when you're online and you want to book a flight ticket, it will tell you which aircraft you're flying, whether it's a Boeing 747, Airbus A350, it will tell you the amount of carbon emission, CO2 emission percentage at the bottom. So you can then choose which one is the lowest standard so that you can fly environmentally friendly. We didn't have this many years ago, 35 years ago. And this is something new that we need to think about. Passenger denied boarding. Can they sue? Was it their fault? Were they late? Did the check-in counter just not like them because they look like a terrorist? So many questions. Drone crashes into a car. Who owns the drone? Who's responsible? Is the drone responsible? Can't hold the drone responsible. Is it the owner of the drone? Is it the manufacturer of the drone? Airline loses luggage. What's the compensation? Is there a limit? These are questions which are legal challenges that we have in Malaysia, but it's very good to think about this and to see, based on these three examples that I've given you on the screen, how big the umbrella is, because it can be a variety. It can range from one thing to another. It can range from an aircraft to an airline. It can range from a drone to an airplane. The list is endless. And with aviation law, it's always going to be expanding. It's always going to be a new piece of regulation coming out, a new standard set on an international level that airlines are going to have to abide by. And it's always a learning curve if you are in this space. So I will stop here to leave some time for questions, and I'll hand it back over to Joyce to see if we have any questions that I can answer.
Thank you, Cassandra, for the insightful talk. And I think all of us have benefited from this interesting yet relevant topic of aviation law. I think we have one question from the floor. I'll just read out for Cassandra to answer. So for MH370, would the family members of the victims have taken actions under both the public aviation and private aviation avenues? How much could the family members have claimed?
So this is a very interesting question. It is one which I may not be able to answer fully because the compensation battle for families of the MH370 victims is a bit complicated. So I'll explain it from two levels as per your question. One is the public aviation sphere and the other one is the private aviation. Two different distinct avenues which were open to families of MH370. Similar to MH17, I think it was MH17, similar to MH17 and MH370, there are two avenues where these can be taken up. One which is on a private avenue, the other one is a public avenue, and the public avenue is almost always overseas, which sit in Amsterdam, if I'm not mistaken. The battle for compensation would actually go beyond legal obligations for MH370. And the reason for this is because the flight route was from Beijing to Kuala Lumpur for MH370, if I'm not mistaken. The reason for this is the plane's final resting place, i.e. if it's a plane crash, would be jurisdiction of where the plane crashed. Problem with MH370 is we don't know where the plane is. Next of kin for passengers who were seeking compensation had to seek compensation in Malaysia, obviously, because it was a Malaysian airline, from the route it departed from, which was Beijing in China. And then under international treaties governing compensation, they would need to take it up with the International Tribunal. The families, however, were not limited to a certain payment, save and except for what MAS had under its terms and conditions, which we didn't have. If I'm not mistaken, in the end, I think the interim payment was not much. It was something like 50,000 or 100,000 US dollars per family that was just given by the airline as compensation. Of course, the most advanced cases usually would be under two courts, like with MH17, because it was shot down and it was a political issue. With MH17, that was taken all the way up to the tribunal. So the tribunal for MH17 involved the district court in The Hague, and that district court in The Hague essentially meant that it was a criminal case because of the way it was shot down. It is different from MH370 because the private avenue would be the more logical route. Given that no one knows what happened to it, it would have to be proceedings brought against the defendants, which would be companies associated with Malaysian Airlines, of course, to blame the airline. It could be the government as well, but I don't think they sued the government in the end. And on behalf of the plaintiffs, if I'm not mistaken, in Malaysia, they were seeking damages for the loss various loss. Different passengers had different losses and different claims. Some moved because they lost their parents. We're claiming for the loss of our parents, children below the age of 18 years old. Had I not had my parent with me, this is how many years they would have paid for my education expenses. So there's no fixed for MH370 because it's a unique case. There is no one they could have claimed $1 million. There isn't one like that because that comes under the private sphere, which is not the public sphere. And this is the reason why it was an issue. Under the Montreal Convention, which is the international treaty I was referring to, Malaysian Airlines essentially said that the next of kin were not entitled to bring a claim for consequential loss. So there were different types of losses. There was a direct loss, consequential loss. So it really depended on what exactly each passenger was claiming for. But in any event, I think Malaysian Airlines had claimed, I hope there's no one from Malaysian Airlines here, claimed that they had gone beyond their legal obligations in terms of paying out whatever they had already paid out in light of MH370 not being found. So can't really answer that question directly for you, but that's what I have. Hopefully that's helpful.
Thank you, Cassandra, for answering the question. If there's any more question, please pop in the Q&A column. I think there's none for now. Before we end the session, I would like to make a few announcements. Please join us again for our upcoming talk. It will be when seizure becomes subject legal remedies for unlawful customs department action. Secondly, please fill in our feedback form and tell us what you thought of the talk today. The link to the form will be available in the chat box. And thirdly, please follow and like our social media accounts if you'd like to. Fourth, as promised, if you would like to speak to our lawyers, we do offer a complimentary consultation over the phone or over video conference for 30 minutes. You may scan the QR code on the screen or access through the link in the chat box. Thank you everyone for joining us today. I hope you had an insightful session with Ms. Cassandra, and we'll see you again.